Almost everyone assumes that once you've got a shotgun certificate, the hard part is over, but that's only half the story. Where you store it, how you transport it, and even what type of weapon you're carrying can all make the difference between staying within the law and committing a serious offence. Today we're going to look at what actually happens when firearms, air rifles and crossbows meet everyday off-grid living. So we're on Chapter 5, Weapons, Hunting and Rural Law. This is part 42 in the video series. And today we're covering shotguns and firearms certificates. So, shotguns are generally easier to obtain legally than rifles. Under the Firearms Act 1968, applicants for a shotgun certificate must normally show no serious criminal prohibitions, safe storage arrangements, and no clear reason why possession will create danger. Firearm certificates are more restrictive. Applicants must normally demonstrate good reason, which may include deer management, vermin control, target shooting, or occupational need. The Deer Act 1991 also regulates the taking of deer, including restrictions on methods, seasons, and humane dispatch. This surprises some landowners who assume deer on private land can simply be shot at will. They can't. Secure storage is a major issue. Guns must normally be stored in approved locked cabinets fixed securely to the structure of a building. This creates a practical problem for vehicle dwellers, boat dwellers, and those living in temporary or semi-mobile off-grid structures. A van, caravan, or boat may not satisfy police expectations for secure storage. And once again, visibility matters. Informal living arrangements often attract additional scrutiny, even where the law itself does not explicitly prohibit ownership. So, transporting firearms. Transport law catches people out surprisingly often. Firearms and shotguns must normally be unloaded, securely stored during transport, and out of sight. Leaving guns visible inside vehicles, especially unattended vehicles, can create serious legal problems. There is also the issue of good reason for possession in public places. Carrying a shotgun across farmland to shoot legally is one thing. Carrying it casually through a town or keeping it loose in a vehicle without clear purpose is another thing entirely. The further behaviour moves away from recognisable sporting or agricultural contexts, the more likely police attention becomes. Air rifles, far less simple than people assume. Air rifles are extremely common in rural and off-grid settings because they appear cheap, quiet and relatively informal, but they remain regulated weapons. In England and Wales, ordinary low-power air rifles currently do not require a firearm certificate, provided they remain below legal energy thresholds. In Scotland, however, most air weapons require certification under the Air Weapons and Licensing Scotland Act 2015. And even where certificates are not required, offences still apply. It is illegal to fire pellets beyond the boundary of land where permission exists, endanger public highways, possess air weapons recklessly, or cause unnecessary suffering to animals. A large amount of informal pest shooting technically falls into legally risky territory once roads, public footpaths, neighbours or poor marksmanship become involved. Again, what people do quietly and what the law formally allows are not always identical. Now, crossbows, bows and offensive weapons. Crossbows occupy a strange legal position because they are heavily associated with weapons yet are not classified as firearms. Under the Crossbows Act 1987, crossbows cannot legally be sold to persons under 18 and minors cannot legally possess them unsupervised. The Offensive Weapons Act 2019 introduced additional restrictions on the sale and delivery of bladed items and certain offensive weapons, reflecting a wider tightening of weapons law. There is also a widespread misconception that crossbows are unregulated because no certificate is normally required. But carrying a crossbow, large knife or similar weapon in public without good reason can still create criminal liability under the Prevention of Crime Act 1953 and related offensive weapon legislation. Biggest misconception of all concerns hunting. Bows and crossbows cannot legally be used for hunting live animals in the UK. This surprises many people influenced by survival culture, historical reenactment or online content from countries with different legal systems. Using bows or crossbows against live animals can lead to prosecution under the Wildlife and Countryside Act 1981 and the Animal Welfare Act 2006. So the important point is this: owning a weapon legally is one part of the picture. How you store it, transport it and use it matters just as much. In the next video, we'll look at pest control and protected species before moving on to traps, snares and poisons.